Good afternoon, everybody. I'm Matt Crowley, the Chief Operating Officer here at the FMA. Thank you for attending our Friday webinar. As usual, we're going to have our presenters, and then the questions will be immediately following all the presenters. If you would like to email a question to us, you can email those to membership@flmedical.org. That is membership@flmedical.org. Any questions for the webinar today, please keep them brief. And with that, I'm going to turn things over to Dr. Giffler.
Good afternoon again. This is Ron Giffler, your FMA president, and welcome. I believe this is the 7th in a Friday series on the legal and financial challenges to keeping our practices viable in this pandemic. We have several new speakers this afternoon, so without further ado, I want to introduce our first speaker, which is Mary Thomas. Mary is new speaking on this format, but not new to us at the FMA. Mary is the Assistant General Counsel for the Florida Medical Association. Graduate of Florida State University College of Law, Mary concentrated on health law and was president of the Health Law Society. She also clerked at the Department of Health in the Office of the General Counsel. As Assistant General Counsel for the FMA, Mary represents the association at various regulatory and administrative agency board meetings, and there are many of those, conferences, commissions for rulemaking. She concentrates on lobbying the Florida Legislature and executive agencies with a focus on rule promulgation at the boards of medicine and osteopathic medicine. She also consults FMA members on various legal and legislative matters. Mary is going to talk to us about prescribing. Go ahead, Mary. Thank you for joining us.
Thank you, Dr. Giffler, for that introduction. Long-time listener, first-time presenter. I'm happy to be here with you guys today. So as Dr. Giffler said, I'm going to be giving an overview of the new non-opioid alternative legislation. For as many of you know that already prescribe Schedule II controlled substances or provide anesthesia services, last year the state legislature passed House Bill 451, which requires certain healthcare providers to inform the patient and discuss the benefits of available non-opioid alternatives, along with providing the patient an educational pamphlet before prescribing Schedule II opioid drugs for the treatment of pain or administering anesthesia. So as the year went on, it was very obvious that there was a lot of problems with this bill. So during the 2020 legislative session, the legislature took another stab at it and passed House Bill 743. And this bill was kind of a mixed bag. They fixed some issues. I think they created maybe another one. But I just want to briefly review the differences between last year's bill and this year's bill before its effective date, which is July 1. So first off, House Bill 743 clarifies what actions trigger compliance with the non-opioid alternatives law. The old language had provided that before providing anesthesia or prescribing, ordering, dispensing, or administering a Schedule II opioid for the treatment of pain, the healthcare practitioner would have to comply. And we'll talk about what compliance means in just a second. So this language was really problematic, particularly in the hospital setting. For example, say a patient came in for surgery. Would the pamphlet and the discussion have to be had with the patient before the patient underwent anesthesia, before the physician ordered the post-operative drug for pain management, before the nurse administered this Schedule II opioid drug for pain, and then a fourth time when the physician prescribed a Schedule II opioid drug for the patient to take home upon discharge? It was really confusing. All of us know that that doesn't really make any logical sense, but the way that the language was written, that's how, in effect, it should have carried out. So the new language removes the dispensing and administering provisions, and now more simply states that if a healthcare practitioner administers anesthesia involving the use of a Schedule II opioid, or prescribes or orders a Schedule II opioid for the treatment of pain, and that's important, then a healthcare practitioner must go on to do certain things. So once again, that removes the administering and the dispensing provision of the 2019 legislation and puts it more clearly into only prescribing and ordering a Schedule II opioid for the treatment of pain. So if you do that, you must inform the patient of available non-opioid alternatives for the treatment of pain. And that's things like non-opioid drugs, physical therapy, or any other therapy that the physician deems appropriate for the patient's condition. Now, it's important to note, if there are no appropriate alternatives to opioids, then the provider does not have to discuss the alternatives. And this provision is unchanged from the 2019 legislation. The second thing a physician would have to do is discuss with the patient the advantages and disadvantages of the use of non-opioid alternatives. And this is particularly important, especially if the patient is high risk for abuse of controlled substances. And this is also unchanged from the 2019 legislation. So then the third component of this non-opioid alternative law is you must provide the patient with an educational pamphlet that's developed by the Department of Health. Now, the 2020 legislation has now clarified that this pamphlet must be printed and provided in a hard copy to the patient. The FMA argued last year and throughout session this year that that pamphlet should be allowed to be given electronically, either via patient portal, maybe some other system that the patient can access, but unfortunately the legislature disagreed with us and expressly included in this year's legislation that it must be printed. We think it's a little confusing because the House specifically is always strong-arming physicians into moving into electronic formats, whether it's electronic medical records or prescribing. So I don't know why this would be any different, but apparently paper makes more of an impact in fighting the opioid epidemic. And then finally, you'll have to document the non-opioid alternatives that were discussed in the patient's medical record. And this is also unchanged from last year. So I would think probably the good thing that came out of this glitch bill, as we call it, is there are now 3 exceptions to complying with the non-opioid alternative law. And that is when a patient is receiving care in a hospital critical care unit, in the emergency department, or in hospice. And so these are really 3 critical exceptions that didn't exist last year. I know that especially in hospice, this was a real burden because Schedule II opioids for the treatment of pain are something that are prescribed and ordered and dispensed and administered very regularly. So also a development over the last year on the regulatory end is what happens now if you are a little unclear with this law and you mess up and you don't specifically comply with it. What's good, is the Board of Medicine going to take your license? Well, fortunately, we spent the last year lobbying the Board of Medicine to come up with penalties that were not, we'll say come up with penalties that fit the crime, as they say. So over the last year, the Board of Medicine has passed some disciplinary guidelines dealing with what happens if you don't comply with the non-opioid alternative law. And so for the first violation, the Board of Medicine considers failure to comply with this law a minor violation, meaning it doesn't put the patient in any harm's way. So for your first violation, you'll receive a notice of non-compliance. And what that means is they're going to send you a letter. It's non-disciplinary in nature, and it's going to tell you what you did wrong and tell you to fix it. So that would be your first hint that something you're not doing something right. So let's say after that you continue to fail to comply with this legislation. Well, after that, the board will use their citation authority. The first citation you'll get is $50, second $75, and third $100. So in the Board of Medicine language, this is telling you, okay, we know this is really not a big deal. Here are very minor penalties for not complying. But if still after the 4th time you've messed up, you're still not getting it, then you'll be moved into the full disciplinary process. So I would think at the regulatory level, they give you a lot of chances to correct what you need to correct. And that's, I think that's a good thing. So we don't expect any changes in the regulatory world stemming from the 2020 legislation. I think that the Board of Medicine will probably keep these same disciplinary guidelines at a low threshold. So once again, just to kind of recap, it's important to note the following. If you are providing anesthesia that does not involve the use of a Schedule II opioid, these requirements don't apply to you. If you are prescribing or ordering a Schedule II opioid for a reason other than the treatment of pain, these don't apply to you. If you are prescribing an opioid in Schedule 3 through 5, even if it is for the treatment of pain, these requirements do not apply to you. So it's fairly narrowly tailored, and we understand that it's still a burden on physician practices to have to print these pamphlets and give it out to patients regularly. But just be clear when it does apply to you and it doesn't. And I believe that just about covers it. We do link to the pamphlet through, you can find it on the Department of Health's website, but we also link to it in our article. And it was originally a 4-page document with pictures of people doing, yoga and things like that. But luckily, we've gotten the Department of Health to bring it down to a 2-page printer-friendly version. So that should help out some of the smaller practices a bit. And I'm here if anybody has any questions.
Thank you, Mary. There'll also be opportunity at the conclusion of all our speakers' presentations to add questions into our, what would you call, chat box. And Matt will go over that at the end again of our meeting. We've had a number of presentations regarding various financial aspects of the COVID pandemic as they relate to our offices, and many of them have to do with the new federal programs, and these deal with money going into our bank accounts, many of them various bank loans or direct deposits. So I thought it would be worthwhile for us to have a real banker as one of our presenters. So we've had attorneys and CPA firms and other speakers, but I thought it was a good idea if we could hear the banking perspective on this. So we have our next speaker is Jarrod Simler. He is currently Senior Vice President of Commercial Banking at Valley National Bank. Jarrod oversees the Broward County Commercial Banking Division and is responsible for all lending, depository, and treasury services. The portfolio, along with the other South Florida markets, include over $1.2 billion in loans and over $1.5 billion in deposits. Valley National Bank works with clients across all industries and includes commercial real estate, professional organizations such as our own, other professionals such as attorneys and CPAs, and homeowner associations. Valley Bank's footprint includes all of Florida, as well as New Jersey and New York. So those two other states should tie in also with COVID financial activities as well. Jarrod received his bachelor's degree from the University of Central Florida and a master's in business administration from the University of Florida. Jarrod calls Boca Raton home with his wife Amy and 2-year-old son Cameron. So thank you very much for joining us, Jarrod. The floor is yours. Virtual
Thanks,
floor.
Can you hear me okay?
Yes.
Great. Well, good afternoon, everyone. Before I begin, I hope all is well given the current circumstances. Additionally, I'd be remiss if I didn't first thank all of you and your teams for your support you've been providing in the fight against COVID-19. You're all doing an amazing job, and from Valley Bank and myself, I just want to say thank you. Dr. Gifler was kind enough to invite me today to speak on the PPP and other CARES Act programs, as well as how we're assisting our clients during this difficult time. This afternoon, I wanted to address some of the more common questions we've been receiving from clients about the PPP program. Before I get into that, I wanted to just briefly mention who Valley Bank is to give some context as to how regional community banks like ourselves and others around the country are assisting with our efforts to help our community. So with that, I just want to briefly give some context here. So just real briefly before we go into some of the PPP matters, just so you know, obviously there's been a lot of news about national banks, large, the big four, the Wellses, the Bank of Americas, and then obviously the community and regional banks. So Valley National Bank, as Dr. Gifler mentioned, is in New York, New Jersey, Florida. And just to give you a brief synopsis of who we are, so before we go into context, publicly traded, founded in 1927. Valley National Bank is traded on NASDAQ. We have over 200 branches across 4 states, $37 billion in assets, over $26 billion in deposits, and we're a fairly large organization with over 3,500 employees. Just real briefly, as far as us as a commercial bank, which is kind of germane to what we're speaking about today, we provide all of the typical commercial banking services, real estate, specifically healthcare financing through a myriad of different industries or subsets within healthcare, and all of the assistance with financing, depository, and treasury services, as you can see here in the business sectors for which we provide services. I won't go into too much of that, as I know everyone here is very specific to their own subsets. Built on with that, as far as treasury solutions, the only thing I really want to mention about this before we go into the PPP is how much of this has come to the forefront of working remotely. So while Valley National doesn't have a branch on every corner, we've very much taken technology as a main initiative for being able to bank all of our clients remotely. So we have a full suite of treasury services products to allow all of our clients from a commercial perspective to really not skip a beat while having to work remotely, whether it's from home or from another peripheral office. We're also vertically integrated across a couple different subsets of organizations that we own. Highland Capital Corporation is one of them for equipment financing, very much respective to what all of the healthcare professionals are dealing with. Insurance services through Masters on the commercial level, and then SBA lending. We have one of the highest and most volumes as far as the state of Florida is concerned for the SBA lending. And the PPP program, as you know, is administered through the SBA program or the SBA division. So we'll talk a little bit more about that, but we are one of the main providers, and that's obviously helped us in getting a lot of these funds out to the needed community. Mortgage and refinance solutions for our clients. So we bank not only on the commercial side, but also the personal side. And then I'll pause here and leave this one up because this kind of goes into what I really wanted to talk about today, which is PPP. So there's really only one data point here to keep it at a macro level, but the most important data point that I wanted to put out there is how Valley is helping. We have processed up until this point over 11,000 applications totaling $2.2 billion. So if you think about that, the average application is really between $70,000 and $100,000. And that speaks to who we're helping, right? We're not helping the huge organizations out there. We have them as part of our portfolio, but it really is, within every specific community, the local Main Street mom and pops out there. So that being said, as I mentioned before, we've approved over 11,000 loans at $2.2 billion. In order for the bank to meet the overwhelming demand, we built the application system to be completely digital and to go online to fund these loans, which I'm sure a lot of you have done through your member banks that you bank with. So that being said, I'm sure everyone on this call has heard about the program. The PPP or Paycheck Protection Program has been in the news quite a bit, and rightfully so. The highlights of the program, or the highlight of the program, I should say, is that it can be 100% forgiven if given certain criteria. There's a lot of good information online regarding the program and how to apply, FAQs, additional guidance for the purposes of this presentation. I won't go into the minutia of it, but I would like to mention some of the highlights that I think are worthwhile. The most common questions from clients are, what is the amount of money I can receive? But more importantly, what is the amount of money I can receive and have it forgiven, right? And what is the requirements do I need to show to accomplish this? And that goes into my third point. What is the supporting documents I need to show? Well, let's start with number one. What is the amount, right? Well, that depends on your payroll expenses, or an equivalent of the 8 weeks that your average payroll was prior to COVID-19. This includes tips, commissions, vacation, sick pay, health insurance, retirement benefits, and state and local taxes. Also rent, utility, mortgage interest, they're all eligible to be deducted. At Valley, at least, we used a very simple Excel sheet to help with this calculation. 2, the requirements, right? 75%, and I'm sure you've heard this in other discussions, 75% of the balance of the loan you have forgiven must go to payroll. Rent, utilities must have contracts in place prior to February 15th to be eligible, and you must maintain your full-time employees equivalent headcount consistent to the headcount before COVID. As part of the new guidance that was released last week, if you reduce your staff, that's okay. But if you reduce it by 20% or more, you must also reduce, your loan forgiveness by 20% or more. And no, an increase in your pay does not make up for a lower headcount. So you can't pay some of your employees more to make up for that difference. And then finally, what do I need to show to get this accomplished, right? As we approach these 8 weeks, you're going to be tasked with providing the banks some of this administrative paperwork. The banks are purely administrator of these loans, and they're going to be the ones that collect all of this documentation to show and prove this forgiveness. That is really where we want to be able to be very clear as far as what you're going to have to show. So like I said before, you're going to have to be able to show payroll for those 8 weeks, retirement contributions and health insurance verification, rental lease agreements, mortgage statements, and utility statements. The good news is this information is readily available online. As far as the specifics, I won't go into specifics, but I will say, like I mentioned before, the banks are administrators of these loans, and the banks will be the responsible party to collect and manage the forgiveness application, which will be given in the moment, just in a moment. So let's talk about forgiveness, the most important aspect that I think is going to be kind of a wave of discussions as we come into the end of May here. After the 8 weeks for applying for this loan forgiveness, the applications for the loans will be processed by your lender, and we have as a bank up to 60 days to give you feedback as to the responses that you provided. And this will all take place as you submitting that forgiveness application that you've seen that have been pushed out, I think earlier in the week or late last week. So some of the biggest things that people have been talking about with this forgiveness, I'll go into. First and foremost, the size, right? So borrowers with PPP loans over $2 million, the Treasury Department warned that these are going to be the targets for audits going forward. And as you might suspect, the application for forgiveness had that box for you to check that if it's over, your organization plus your affiliates are over $2 million, you need to raise the red flag for that. And so in not so many words, self-disclose this. The recent guidance that came out forms an instruction as far as how you define these affiliates. So I really advise, this is kind of where I would take a step back as a banker and advise all of the participants who are listening today to really talk to their CPAs and legal counsel if this does apply to them, especially over $2 million. But let's go into some of the more common stuff, which is the forgivable costs, right? So what are they? The SBA's guidance recently provides for 4 broad topics or broad categories for what can be forgiven. Payroll costs, business mortgage and interest expenses, as we mentioned, business rent or lease payments, and then utility payments. Subject to some exceptions, forgiveness is generally available for costs incurred with respects to these items. We call them covered period of 8 weeks prior to the beginning date the PPP loan was dispersed. As with prior guidance, right, the SBA requires that at least 75% of the forgiven amounts be attributed to payroll costs. So let's talk about what those payroll costs are. The SBA's guidance allows for the PPP borrower to deduct payroll costs paid or incurred during that 8-week period. They also issued guidance on an alternative payroll covered. I had a lot of clients of mine ask me and said, hey, Jordan, my payroll doesn't specifically align with the specific guidance that came out as far as when that 8-week period has occurred. Payroll costs are incurred or considered incurred on the day that the employee earned the pay. This distinction allows employers some flexibility in the timing of their PPP funds. The SBA provides for, like I mentioned, that alternative payroll covered period that caters to borrowers with a bi-weekly or more frequent payroll schedules. This provides that flexibility that a lot of the users of these PPP funds were demanding, and the borrowers who opt out or opt for the alternative payroll covered periods are still required to use the standard covered periods for other costs. Let's talk a little bit about compensation to owners, right? So the SBA's guidance allows for the forgiveness of amounts paid to owners, so maybe the self-practitioners of this group. The amount eligible for forgiveness is capped at the lower of $15,385, which is the 8-week equivalent of $100,000 per year, which is, if you were filling out that calculation, was the cap for the amount per employee. Anything more than that was clawed back. For each individual, the 8-week equivalent of the owner's applicable compensation in 2019, whichever is less. So it gives you a little bit of give as far as how you want to calculate that. There's also eligible non-payroll costs, right? We just talked about that 25% rule. So the non-payroll costs eligible for forgiveness consists of the following categories. Covered mortgage obligations, right? This is the amount of the business mortgage interest payments during the covered period for any business mortgage obligations on a real or personal property incurred before February 15th. This guidance defines business mortgage interest payments as payments of interest not included any prepayments or payments of principal. Any business mortgage obligations on real or personal property that was incurred before February 15th, as I mentioned. This also applies to rent obligations for that same time period and covered utility payments. The SBA's guidance further provides that an eligible non-payroll cost must be paid or incurred during that covered period. Moreover, the SBA provides that eligible non-payroll costs must be eligible must be more than 25% of that total forgiveness amount. So what do we mean by that? So if your payroll is reduced, so will the forgiveness of your loan, as we mentioned before. Some of the most important things that I wanted to mention today was obviously the safe harbor. The safe harbor rules, the guidance on those, which were provided last week, provide some clarification for safe harbor on full-time employees. And so this is some of the technical stuff that obviously I want everyone listening today to talk to their bankers about, as well as their CPAs and attorneys. The SBA's guidance recognizes safe harbor that exempts some borrowers from losing that forgiveness based on a reduced employee levels. I think all of us out here as business owners have discussed bringing back our employees, but maybe not at the same level that we've had before COVID-19. And the SBA has provided that guidance to allow for that. So under the safe harbor, a borrower is exempt from the reduction in loan forgiveness based on the FTE, the full-time employees levels, in the period beginning from February 15th, 2020, all the way to the end of April 26, 2020. And two, the borrower by no later than June 30th, 2020, restored its FTE employee level to the FTE employee level that existed during the borrower's pay period that included February 15th, 2020. And then it goes into further clarify not only the full-time employees, but also salary and hourly wage reductions. So the CARES Act reduces the borrower's loan forgiveness amount where the employer reduces certain employees' salaries and wages. Under this rule, the actual amount of loan forgiveness may be reduced if the salary or hourly wage of certain employees was less during the covered period or that alternative period we were just talking about, compared to January 1st, 2020 through March 31st, 2020. This reduction applies only for employees whose salaries or hourly wages were reduced by more than 25% during the covered period or that alternative period as well. While not referenced in the new guidance, this reduction generally does not apply to employees' compensations in more than $100,000. So I know this is a little bit of the technical side. I definitely want to encourage everyone to go out and reach out to their CPAs and attorneys for that piece. But finally, I wanted to give the bank's perspective on what happens if not approved for this forgiveness, right? Everyone is talking about getting forgiven, but there may be a portion under this new guidance that may not be forgiven. Your lender may allow you to provide additional documentation if you did not provide sufficient forgiveness documentation up front. There may be some back and forth to help reconcile that. We do that all the time. But otherwise, your outstanding balance will continue to accrue interest at 1% for the remainder of that 2-year period. You know, there was a lot of initial discussion about whether or not that 2-year period would be extended to 5 years, or would there be some type of takeout financing for this? None of that guidance has been released yet. I think that's too early to comment on that. But this is what's out there right now as far as that 2-year payment. So as I mentioned before, your lender should be providing you with instructions very shortly as the first tranche of funds is coming up on the 8 weeks with how to apply and submit for that forgiveness application. Most likely, they're probably going to do it in a digital format. So I strongly recommend you ensure your thorough bookkeeping now and make sure that your practices are up to speed so that you can, accounting practices, so that you can make sure that you're able to deliver all of the necessary supporting documentation to your bank. And with that, I just want to say thanks again for inviting me today. And once again, I appreciate everything you're doing to assist us, obviously during these uncertain times. Thank you.
Thank you very much, Jordan. So in summary then, I think you said, correct me if I'm wrong, if an amount is not forgiven, you have 2 years at a 1% interest extension. Is that correct?
That is correct.
Okay. Thank you very much. I'm sure we'll have some questions, but our final speaker today is our own Jarrod Fowler. He is in charge of the Florida Medical Association's healthcare policy and innovation, and is very key in all the financial aspects of medical practice, including myriad federal and state regulations, and advises our Council on Medical Economics and anyone else that has a question about these areas. So Jarrod has been a regular participant on these conferences and would like to give us the latest updates today. Thank you, Jarrod.
Hey, thank you, Dr. Gifler, and thank you everyone who's listening. I thought today, since I have kind of a light update, since we're still, HHS hasn't issued too much new information over the past week, I wanted to talk about first a study that came out, which I thought was interesting and pertinent to this group. It was from the Commonwealth Fund, and basically it was a study on outpatient care during the pandemic. And this is a follow-up to a previous study that the Commonwealth Fund conducted that found that the number of outpatient visits across a number of physician specialties declined nearly 60% due to the pandemic by early April. They have now found in this follow-up study that since that time, the number of outpatient visits has rebounded, though it is still roughly 1/3 of what it was before the pandemic. And the rebound in visits, interestingly enough, according to this study, was more due to an increase in in-person visits rather than an increase in telemedicine visits. Of course, we know that the pandemic has not affected all physicians equally. The relative decline in visits remains largest among surgical and procedural specialists and pediatricians. According to the data, pediatricians have seen the slowest rebound of any specialty that was tracked, and outpatient visits for children continue to remain quite low, which I think really underscores the need to provide dedicated relief to Medicaid providers, such as pediatricians, and that may have been ineligible for the federal emergency funding that's been distributed thus far. Getting relief for Medicaid providers continues to be something that we're strongly advocating for, and a central focus of our federal lobbying efforts. And from what we're hearing from our federal lobbyists, this is something that HHS is working on, although we don't have details to share at this time, as none have been released. But it was, again, kind of an interesting study showing that there's been an enormous 60% drop-off in outpatient visits across a wide range of specialties, and that to know that that has rebounded at the point where we're down only by 1/3 relative to where we were before the pandemic would seem to be a good sign for a lot of physician practices. Obviously, still very few businesses can sustain a 1/3 decline in revenue, and certainly physician practices can't be expected to sustain a 1/3 decline in volume. But at least preliminarily, the findings from the study show that physician outpatient volume is back on the rise, that patients are getting medically necessary care that they may have put off as a result of COVID-19 that they need, and that physicians need to be able to provide. And hopefully this is a trend that will continue to be validated, and that will continue to move us towards seeing outpatient volume that is closer to pre-pandemic levels, because we know that a lot of people have put off medically necessary care due to this pandemic, and we hope again that this trend continues to move in the right direction. So 2 additional updates that are pretty brief. First is, many of you know from our last webinar, I mentioned that HHS stated that with respect to the second tranche of emergency funds provided under the CARES Act, that providers that attested and submitted tax forms and loss estimates should receive a payment within 10 business days. Well, as it turns out, even though that's what the HHS guidance stated and actually continues to say last I checked, It turns out that many providers have not received payment under the second tranche of funds within 10 business days of applying. And we're hearing that this is widespread, that it's happening in other states, that it's happening, generally. And I will say that on May 14, HHS stated in their updated FAQ, which they've updated many times, that they are still in the process of reviewing providers' uploaded financial information, and that payments will go out weekly on a rolling basis as this information is validated. HHS also clarified that it may seek additional information from providers to complete its review. And again, this is the most up-to-date information I have to share at this time. So if you're wondering though where your second tranche of payments is based on having submitted your data to HHS and having waited 10 business days, know that you're not alone if you haven't received it. We do encourage providers though who submitted data and who may have questions about where they are in queue, what's happened to their applications, to please call the United Health Group provider support line at 866-569-3522. Again, 866-569-3522. And I think we'll send that number out in an email after this webinar has concluded as well. So don't worry about writing that down or if you miss it or anything else. But in any event, we also encourage our members, of course, to contact us with anything that they're hearing. If you've received your second tranche of payments under the general distribution, we'd love to hear from you as well. We're just trying to keep a pulse on what's happening with our providers so that we can continue to lobby for additional relief or for additional clarification in the policy guidance as it's needed. As many of you know, this is a rapidly changing environment, and HHS, as I mentioned, has continued to issue new guidance on an almost continual basis. And so for that reason, I would also encourage everybody to continue to not only check the FMA news for updates, but to also continue to check the HHS Provider Relief website that exists on a regular basis, and the corresponding FAQ document that HHS has released that is on that webpage, because they continue to update the FAQ document with additional guidance and clarifications. Actually, I think they've done so at least twice in this past week. So it's being very regularly updated, and we strongly encourage people to look at that information. In addition to clarification on existing distributions of funds, HHS will likely use that provider relief webpage to continue to announce any additional targeted distributions that go out to providers. That has sort of been their landing page for all the relief they've sent out so far under this program, and we anticipate, have no reason to believe that it will not continue to be the landing page for that information. And so it will be worth checking for updates on that page periodically, in addition to, of course, checking for us here at the FMA through the FMA news, which I know that just about all of you receive. So final thing I wanted to mention, HHS came out with an announcement this Wednesday. And basically the announcement was just to remind eligible providers that they have until June 3rd of this year to submit their revenue information to support receiving an additional payment through the general distribution, that is a second tranche of payments through the general distribution, and to accept the applicable terms and conditions that are set forth by HHS. They mentioned that all providers who automatically received an additional general distribution payment are to provide HHS with an accounting of their annual revenues by submitting tax forms or financial statements, and that providers, again, have to accept to the terms and conditions set forth by HHS if they wish to keep these funds. I'm not going to read the entire announcement from HHS verbatim because I think that would be boring, but know that we sent out an alert in the FMA news with a link to that announcement. And if you go to the HHS provider relief page, you can read the announcement in full. Again, the bottom line is that HHS is reminding providers that by Wednesday, by June 3rd, that providers need to submit additional revenue information to support receiving an additional payment under the $50 billion general distribution that went out, and to accept the applicable terms and conditions set forth by HHS. They do note that providers who have cases pending before HHS for adjudication with regard to eligibility for the general distribution funding will not be impacted by disclosure, and that additionally, again, all cases needing individual adjudication will need to be received by HHS no later than June 3rd, 2020. So I know that a lot of people have had, questions about basically, do they need to be submitting more information to HHS? When do they need to be testing by? Is that date being moved around? And again, I would refer you to that announcement so that we can make sure that anybody who received money from HHS is able to accept the terms and conditions if they agree to them by the applicable date, or make a determination not to. And that is really all I have at this time. There's still a lot going on. We, again, expect more targeted distributions in the near future, hopefully one for Medicaid providers. Again, HHS continues regularly to update their guidance and provide clarifications and updates to frequently asked questions. And we look forward to sharing that information as it becomes available. We're also very closely monitoring what happens in Congress. While nothing is anticipated to happen till at least sometime early June. As many of you know, the HEROES Act that passed the House contained numerous healthcare provisions related to both the PPP and the Act also provided additional funding to the HHS emergency funds that many of you have been receiving distributions from. And that is something that we are tracking very closely. And with that, I suppose I'll close, and I'd be happy to take any sort of questions. Again, we urge everybody to keep a close eye on the HHS Provider Relief website and to keep a close eye on the FMA news, and just to continue to monitor for announcements and new information, which will surely be forthcoming.
Matt, do we have any questions?
Yes, sir. We have quite a few. And I'll start with Mary. Mary, is HB 723 replacing HB 451?
Essentially, yes. House Bill 451 from 2019 created Section 7 in Florida Statute 456.44, which deals with controlled substances. And then this year, the legislature passed what we call a glitch bill, which fixes certain provisions of that Section 7. So it basically amends House Bill 451, but yes, it's gonna, I guess, essentially replace it.
Okay, we have quite a few for you here, Mary, so stay with us. For a pain practitioner, they provide refill for my opioid every month. Do they have to provide this brochure every month or just the first time only?
This is a difficult question only because the Section 7 of 456.44 is completely silent on this issue. So unfortunately, I would have to say if it's a refill, but from what I understand, you can't refill Schedule 2s, but I believe you can give multiple prescriptions in certain circumstances. But if the patient is presenting and you are writing a new prescription, then unfortunately, my reading of it would be yes, you would have to comply with the non-opioid alternative law.
Great. And next one would be, while doing telemedicine, how do we provide this brochure?
So that's an interesting question because generally pre-COVID-19 taking over, there was a prohibition on prescribing controlled substances via telehealth. Right now, Emergency Order 20-002 has allowed for the prescribing of controlled substances via telehealth, but that expires May 31st as of right now. And so don't forget, House Bill 723 doesn't go into effect until July 1. So now let's just say, hypothetically, the Emergency Order 002 continues to get extended, and that now it's going to overlap with July 1, where you have to provide the printed brochure. We would probably ask the Department of Health to make a specific exception in the emergency order for that, or I would say just provide it electronically. I don't think that the department would be coming after anybody for not mailing a pamphlet after they've written a prescription. So that's interesting. But once Emergency Order 002 expires, which is right now is May 31st, you will no longer be able to prescribe Schedule 2s for the treatment of pain over telehealth.
Okay, and last question for now for you. Does this apply only to Schedule 2 and not lesser narcotics?
Correct. So setting aside the anesthesia provision, well, actually even anesthesia, it only applies if it's a Schedule 2 opioid that you're using for anesthesia. And then also if you're prescribing or ordering a Schedule 2 opioid for the treatment of pain. So if it's a Schedule 3, 4, or 5 for the treatment of pain and it's an opioid, you don't have to comply. If it's a Schedule 2 non-opioid, then you don't have to comply. So it's very specifically a Schedule 2 opioid for the treatment of pain.
Okay. Mr. Simler, I have a couple questions for you.
Sure.
I've heard you can provide hazard pay to employees. Would this help meet the 75% threshold?
The hazard pay is interesting. I mean, a lot of that goes into the healthcare field, which is probably why you're asking about it. I believe the current guidance addresses the hazard pay and makes that eligible, but that's one that I definitely would want to circle back to you on.
Okay. Any idea if utilities can be paid after the 8-week period? Utility billings are typically 1 month back. I know there was an exception made for payroll.
Yes, utilities during that covered period, if they're a month behind, can still be counted and qualified. You know, the intent is to cover that 8-week time period or the alternative time period that's mentioned in the updated guidance. So if your utilities payment is 1 month behind, you should still be able to calculate that and submit that as part of your forgiveness.
Okay, and then another question, are you aware of a breakdown or a list of everything that could count as a utility? Some people want to know if EHR, electronic health records, or things such as security systems can count as a utility.
I think all of those are eligible. The biggest thing is going to be adhering to that 75-25 rule. I think from a standpoint of calculating or at defining what utilities are, those range or differ slightly from industry to industry, but let's use electronic medical records. That's definitely an operational cost, and as long as it meets that 25% threshold, you're allowed to utilize that as part of the forgiveness, along with all the other utilities or payments. I saw something about pensions as well. That's included as retirement, and that will be honored as part of the forgiveness.
Okay, our next question could probably go to Jarrod, Mary, or Jeff, whoever wants to take it. When CMS 1135 waiver expires for telemedicine, heard about June 20th, but cannot find any article on CMS website. Thanks.
Yeah, so the answer to that is, or what is listed in the FAQ document on CMS's website is that the telehealth waiver will be in effect until the public health emergency declared by the Secretary ends. So that is when it will end, is when the public health emergency issued by the Secretary ends. I have not heard of any indication that any telehealth guidance issued by CMS is going to end or on a particular date. One thing I want to mention, though, is that with respect to telehealth flexibilities, keep in mind that private payers can and do have rules that differ from HHS, and that some of their flexibilities may expire before the flexibilities provided by HHS expire, or at different dates altogether. So while the flexibility provided by CMS won't end until the public health emergency ends, keep in mind that Florida Blue, United Healthcare, et cetera, may choose to terminate some of their flexibilities on a different date, and that you should continue to check with the provider manuals from each payer that you contract with to make sure that you know what their applicable policies are at a given point in time. Thank you.
Okay, the next one's for Mr. Simler. Under the PPP, can an independent contractor, such as a physician working in locum tenens, apply and be accepted?
Yes, the independent contractor is definitely allowed to apply. They will be subject to the same clawback rules that any employee would be required to adhere to, which is that $100,000 clawback threshold. But yes, absolutely. And we have clients all the time that are independent contractors or 1099, and they've been successfully applying and receiving funds under the PPP loan process.
Mary, how can they get a copy of the updated non-opioid form to give to their patients?
The brochure is located on the Department of Health's website. If you just Google Florida Department of Health non-opioid alternative, it'll come up, or I believe we'll be sending out a copy of the article that we published on it, and we also link to the pamphlet in that article.
Okay. A couple of people have asked about links on the Medicare reimbursement issue. For those, if you just want to send an email to membership@flmedical.org, that's membership@flmedical.org, Jarrod can send you those links directly. I believe you've already covered this one, Mr. Simler, about PPP loan being used for pension funding. I know you said that is proper. Could you go into that a little bit more?
Well, it all kind of falls under the retirement expenses. So whether it's a pension plan or qualified retirement expense, those all get calculated. If you haven't applied so far, or I should say conversely, if you have applied, you'll notate that on the calculation Excel spreadsheet, it takes into consideration the retirement, and that's included in the gross that you're able to apply for. So retirement, whether it's pension or other types of qualified retirement expenses, those are definitely taken into consideration for that 8-week period that the PPP program is trying to analyze.
Okay. About the PPP, we also have another question. Is there a database showing where the PPP loan funds were distributed?
The SBA does release stats. I'll have to see what the most recent one is, but they break it down into financial institution as well as state. So there's a lot of good data out there that shows where all the funds have been circulated to. And then obviously they break it down to the amount of employees because it discloses that on the application. Much like some of the press that you saw initially for some of the large publicly traded companies that receive backlash and PPP money. All of this is very much out there in the public domain. So, you don't have to go very far to see how all of these funds are allocated.
Okay, this next one's for Jarrod. What are you hearing about the future of telehealth parity payments beyond the COVID crisis? Our family medicine practice is currently 100% video visits and telephone appointments, and the majority of patients like it. We want to continue the model with only new patients and annual physicals in the office.
What I would say is that that's that is the $100 billion question that everybody is asking is how long is this flexibility going to extend once the crisis is over? And so, as I previously noted, HHS has said that its waiver is going to extend until the PHE that's been declared is over. And there's a big question as well, when is the PHE going to be over, right? If we have second, third wave infections, as long as there's a risk of that, I mean, we could imagine the PHE being extended for a very long time. But then there's also a question of, so what will happen on the legislative side, right? Will Congress touch the issue of telemedicine parity in the form of legislation? Certainly that is FMA and other organizations have advocated for, is addressing telehealth parity through some form of legislation on the private payer and particularly for ERISA payers. But again, what Congress will do ultimately is up in the air, and how long the PHE will last is up in the air. We are definitely doing everything that we can to make it clear to HHS that we believe that the flexibilities provided for the course of the pandemic should be continued indefinitely. I think we've learned through this that the previous restrictions on telehealth were not good for patients, that they did limit access to care, and that clearly this is something that's tremendously beneficial to a lot of patients who would otherwise have difficulty receiving care. And so just know from an advocacy standpoint, we're with you, and we're doing everything that we can on this. And all of organized medicine, we're working across state boundaries and with other national societies to do everything we can to push for permanent flexibilities there. But the truth of the matter is that that is something that is up in the air. They'll be aware again that we're doing everything we can to fight for a permanent extension of the existing flexibilities and for further expansion of flexibilities as it relates to telehealth. And one piece of that certainly would be parity, both continued parity for audio only E&M visits relative to synchronous real-time audio and video E&M visits, and also parity with respect to the rate at which private payers would be required to reimburse physicians for telehealth services relative to in-person visits. Those are all flexibilities we either look to acquire or extend, and that we would in any case like to see made permanent.
Let me just add for those first-time participants, while this epidemic will surely end eventually, one thing we've heard mentioned numerous times is that changes and promotion of telemedicine is here to stay. This has been the time when telemedicine has really shown its potential, but we need to make sure that our compensation is appropriate. And so both state and federal redress are needed, and we do have lobbyists at both the state and federal level working specifically with the FMA and also with other organized medicine associations to work toward this end. Any other questions, Matt?
Yes, sir. To Mr. Simler, can you share with us where to find the SBA guidelines that you referred to during your presentation?
SBA.gov. That's the best place to go.
Very easy. On that, I'll let everybody know that if you did not feel like you got your question completely answered or you had additional questions, please feel free to email us at membership@flmedical.org. That is membership@flmedical.org. You'll also be receiving an email after this presentation with our contact info in it, as well as a link to Ms. Thomas's article that she wrote in the FMA News yesterday if you want to go in more depth in that topic. And with that, I will turn it back over to Dr. Gifler.
I wanted to thank everyone for participating, especially our presenters, our guest presenter from the bank, Valley National, Jordan Simler. Thank you very much. Mary Thomas, thank you and welcome to the Friday sessions as a presenter. And Jarrod, you are always a fountain of information as well. And thank you, Matt, for making this all happen. Everyone have a nice, pleasant, safe Memorial Day weekend. Thank you.